Here, first, on the legal side of all of this, reaction to today's ruling and what it means. Fox News legal analyst Gregg, Jarrett, Harvard law professor Alan Dershowitz is with us. All right, well, let's talk about this 6-3 decision. Professor, I'll start with you. And you must show proper cause. I thought Justice Thomas, writing for the majority, kind of nailed it. There's no other constitutional right where you have to show just cause or proper cause.
Well, the New York state law was very broad and very vague. If you read the majority decision together with the concurring opinion of Justice Kavanaugh, who helped form the majority, it was 4 votes, and then Kavanaugh and Roberts comprised the 6, and then the 3 dissenters. Kavanaugh says this doesn't stop a state from requiring registration, background checks, how old you have to be, what kinds of guns. So it doesn't tell us very much about whether states can pass laws restricting AK-15s or requiring people to be 21 instead of 18. We're going to have to wait to see in subsequent decisions whether or not the thrust of the majority, which is exactly the way you described it, or the concurring opinions' limitations on the majority ultimately become the law. It's a work in progress.
You know, Gregg, if you're talking about the right to carry, we're not talking about carrying an AR-15. It would normally be a revolver. It would be a pistol, 9mm or 40, whatever it happens to be, small, compact, for protection. That seems pretty obvious to me, but I wouldn't doubt that the state legislature in a liberal state like New York tries to work around this decision probably almost immediately. Do you concur?
Oh, they probably will. They no doubt will. The people who voiced utter shock and disbelief at today's decision are either clueless or they weren't paying attention. This was foreseeable. It was predictable because it was consistent with the prior Supreme Court decisions. Justice Thomas waited until page 62 to point out that the Second Amendment isn't a second-class right. And over on CNN, I was amazed and amused to watch legal analyst Jeffrey Toobin throw a hissy fit as if that's some new and novel concept. If Jeff had actually read the decision, he would have noticed that Thomas's statement was in quotes. Where did it come from? It came from the last major Supreme Court decision 12 years ago, which Toobin either didn't read or he didn't remember. He also became unglued, saying that conservatives want no rules, no regulations. It's going to be a free-for-all, as if the Supreme Court would abide by that. No, the Supreme Court in the Heller decision stated very clearly that reasonable restrictions are permissible, and indeed, the court then identified several restrictions that were perfectly okay. So we will have to wait and see whether things like background checks and red flag laws with due process are permissible, but I suspect those things would be.
Professor, does this immediately negate the current law in New York? In other words, would people in New York now have the ability to apply for a concealed carry permit and be granted it and not have to prove proper cause?
Yes, I think that's right. I think the New York law has been struck down, but there will be attempts by New York, as Gregg says, to adapt to the Heller decision and to this decision and to permit some kinds of regulations. Remember that the Second Amendment talks about a well-regulated militia, and militias at the time of the framing were well-regulated by the states. And so the states still reserve to themselves residual power to do reasonable regulations. What the court said today is that New York's regulation was not reasonable because it gives too much discretion to administrators to determine what constitutes good cause. If you feel frightened, if you've had a subjective experience, you can't get a permit in New York. You have to show that you've actually been threatened. And New York permits have been very, very hard to get. And so I think what the court is saying is if New York wants to tighten up its law and make it more objective, that was the word used by Justice Kavanaugh over and over again. So Kavanaugh's concurring opinion with Roberts is an invitation to the states to do better, whereas I think Justice Thomas's decision set out a framework for analysis which suggests that not all efforts to tighten up the laws will be accepted. It's again a work in progress.
Let me go back to the point that you were making about a well-regulated militia. Our own government at the time defined the militia as the people as a whole. That's how it was defined by the government.
But it was states. Remember, there was a big fight between Hamilton and Jefferson about whether there should be a standing army. And the Second Amendment was part of a compromise to give the role of the armed forces over to state militias. So states do have some power. And, you know, under our system of checks and balances and federalism, you're never going to get a perfect solution. There's always going to have to be a balance struck between state and federal, between the judiciary and the legislature, and we're going to see this work its way out over the next probably decade.
We'll give you the last word, Gregg. Jarrett.
Yeah, look, the states and the founders intended that the Bill of Rights, every single one of them, all 10 of them, be primary, be fundamental rights. That's how it was ratified. The trouble with the New York law is it shifted the presumption and the burden to the citizen to prove they had that right. That is inherently wrong, according to our constitutional interpretation of the Second Amendment and the Bill of Rights.
All right, Gregg, Jarrett, thank you. Professor, always good to have you as well. Thank you.